Tonight, we're hearing from one of the nation's top constitutional scholars, a professor at UNC Chapel Hill.
WRAL's Lena Tillett spoke to him about the implications here of this ruling and what could happen next.
And this ruling will almost certainly head to the U.S. Supreme Court. Similar cases were made in several other states, including North Carolina. And what happens next could have enormous implications for next year's election. And joining me now to help make sense of all this is Michael Gerhardt. He is the Burton Craig Distinguished Professor of Jurisprudence at UNC's School of Law and the author of the upcoming book, The Law of Presidential Impeachment. Professor Gerhardt, thank you so much for joining us. Can you briefly just describe the Colorado Supreme Court's ruling here and the constitutional argument it makes?
Yes, I'm happy to do that, and thank you for having me. The Colorado Supreme Court essentially ruled that under part of the 14th Amendment to the United States Constitution, Donald Trump meets the definition of the kinds of people who are ineligible because they engaged in or encouraged insurrection or gave comfort and aid to America's enemies. According to the Colorado Supreme Court, Trump was found, as a matter of fact, to have incited insurrection. And as a result, he is ineligible under the terms of the 14th Amendment.
So a lower court ruling in Colorado said that the office of the president does not apply to this particular clause in the 14th Amendment. So how does this court justify that it does? And where do you fall on this?
I agree with the best scholarship on this issue, and that's the foundation on which the Colorado Supreme Court rested its decision. The best scholarship on this issue of who is covered by Section 3 of the 14th Amendment suggests that the president is, of course, covered. The actual language of Section 3 of the 14th Amendment refers to officers of the United States, which effectively means everybody who serves under the President of the United States. And it would be absurd to think that everybody but the President or Vice President is rendered ineligible because they incited insurrection. Keep in mind, this section was drafted in the immediate aftermath of the Civil War. And if the President were not covered, that would have meant that Jefferson Davis would have been eligible to run for the presidency of the United States and even win it and occupy that office. And I think that's an absurd consideration given the agenda of the people who drafted the 14th Amendment.
So this ruling, of course, has not actually taken effect yet. The court is giving former President Trump's legal team time to appeal it to the U.S. Supreme Court. And the high court, of course, has a 6-3 conservative to liberal split. But this argument by Colorado Supreme Court is an originalist reading of the Constitution, something that I would think conservative justices may ideologically fall in line more with. So where do you see the justices falling on this?
I think that's a really important point. I think this is going to be a challenge for the Supreme Court because the justices, as you've just said, make a lot of sort of pronouncements about how we all ought to follow, and particularly how they ought to follow the original meaning of the Constitution. And the scholars who've put together the best research on this are originalists. And they suggest that Trump is covered by the language of that amendment. And it would be ironic for the justices to disregard the plain language and the original meaning of the language in favor of some other kind of research or finding that ignores the language and original meaning.
So many Republicans are furious, incensed about this, saying that this should be left up to voters. How do you respond to that?
I respond that the Constitution of the United States controls the situation. They may be upset by it, but the language of Section 3, and I encourage your listeners to read it, plainly says that anyone who's sworn an oath to defend the country, to defend the Constitution, but incites or engages in insurrection is ineligible to serve in an office of the United States. And that seems to fit Trump very neatly.
Top Republican state lawmakers and our state senator Tom Tillis both said today that they are now looking at legislation that would only allow top federal courts to make ballot decisions like this. What do you make of that?
Well, Senator Tillis, I assume, is talking about trying to create federal legislation on this question. And I doubt very seriously he's going to get a majority in the Senate to agree with that. But even if there were such a federal statute, it's probably unconstitutional to exclude state courts from rendering decisions like the Colorado Supreme Court just did.
Professor Gerhardt, thank you so much for your insight tonight. It was very helpful.
Thanks for having me.